There was very little pharmacology and scientific data that was available at the time the act was, the Controlled Substance Act was enacted. But there was by then, at least, the establishment in the School of Pharmacy in Mississippi, this attempt to kind of get a better quantitative analysis of marijuana to find out whether it really did have any efficaciousness, whether it was really the harmful substance that people were saying it was, or whether it was the benign substance that organizations that as early as the 60s were advocating for its legalization were suggesting that it was. And it was a rather rapid, escalating effort in the early 70s for about a period of 4 or 5 years to kind of gather all of the scientists and medical practitioners and others who were interested in the subject to kind of come to some consensus as to whether or not this was really harmful or not. And the consensus was that it was harmful. It's not a consensus that was just held between 1970 and 1975. It's been a consensus that's been held uniformly until today, which is the reason why, from a law enforcement standpoint, when we look at something like Prop 215, law enforcement doesn't look at it from the standpoint of this is something which is an inherently good substance, something that people recognize is helpful and healthy, and therefore attempts to restrict its use should be viewed very narrowly. It's just the opposite. It's something which is inherently harmful and something that can be dangerous, and in chronic use and with a high concentration of tetrahydrocannabinol that we're seeing can be very, very harmful. And so any attempt to sort of cut into the restriction will be viewed very narrowly. And so up until the last couple of months, we'll give it a couple of months, when there were some suggestions that there would be a re-examination of the marijuana laws, or at least the federal enforcement of those laws, the stage was very well set this way. Whatever it was that California had decided to do, it had no effect on federal law. This is not just something that was pronounced by the Drug Enforcement Administration or by the Attorney General of the United States. It's something that, for all intents and purposes, the Supreme Court in the Race case had confirmed, and that is that under no circumstance would federal law, as it related to this substance, be subordinated in any way to Prop 215. It still created, quite frankly, in the minds of lots of folks, not necessarily in law enforcement, but I think in the general community, some confusion, because you had basically these two competing, we'll call them competing attitudes. You had the voters of California, which for good or will or ill had passed 215 with not so well-defined sort of guideposts for exactly how that would play out. And you had federal law that was an absolutist prohibition on the use. And so federal law enforcement wasn't really caught in between, because federal law enforcement never really did take the approach that it was its responsibility to enforce every single manifestation of the misuse or cultivation of marijuana. As a matter of its priorities, and priorities are set all the time, federal law enforcement, certainly in California, I think in other parts of the country as well, had established certain criteria. And I won't go into the details of what the criteria are, because invariably, whenever I talk about what the prosecution criteria are, somebody says, well, that's a good sign then. If we just sort of fall slightly under the criteria, we can avoid federal prosecution. We don't want to do that because it sends a false message that there is this safe harbor that's been carved out, for people who want to cultivate or otherwise, dispense marijuana or any other, commit any other kind of federal offense as far as we're concerned. Bottom line on all of this is that we had, as a matter of priority, established the kinds of operations that we would concentrate on. We said this, I think, at least I said it, and have been saying it for the whole year that I've been back as U.S. Attorney. And I don't think that it is remarkably different, or was remarkably different than what we had been doing for the 10 or 15 years before. And it certainly wasn't much different than what we've been doing before or after the passage of the California Prop 215. And what it comes down to fundamentally is this. We are not interested in users. The federal government doesn't concern itself with the use of marijuana as an object of our enforcement efforts. We're not even interested in people who have a legitimate claim to being sort of compassionate providers, or those persons who contend that they are cultivating marijuana for the purpose of providing it to qualified users, patients, people who have arguably prescriptions or certifications or letters of suggestion from doctors, any approved sort of authority for using marijuana. They could care less about it. But we differentiate between those people who are claiming such conduct and those who are engaged in either the cultivation or the trafficking or the distribution of marijuana for profit. And that's why when the Attorney General, Brown, issued his guidelines for how he understood or recommended to local law enforcement Prop 215 should be applied, I think all four of the U.S. attorneys in California applauded that we finally had some clear, fairly concise guideposts for how the state was going to be conducting its affairs vis-a-vis enforcement, because, quite frankly, it was on all fours. It squared with exactly what we've been doing, and still does. It still represents, in my view, a very reasoned and sensible approach to how precious law enforcement resources should be used in an area where there is this, we'll call it, conflict of view. But it shouldn't provide any comfort to anyone who's engaged in storefront dispensary or commercial operation that somehow or another the federal government is going away. And and I would be very surprised. We have not had any specific pronouncement on this. I don't expect a specific pronouncement on this. I would be very surprised if in Washington, in the new administration, there would be any change, any substantial change at all in this approach. And the reason that I say that is that the Attorney General, in his sort of offhand comment, has basically said we are not interested in using the federal enforcement authority as a way to avoid the medical marijuana statutes or laws that have been enacted in the various states. So, for all intents and purposes, if someone is in compliance with the state regulations as espoused by the State Attorney General, there is little likelihood that federal enforcement efforts will be focused on those operations. Now, the devil is always in the details. We can discuss, perhaps in answer to some of your questions, or after what my good friend here, the one who has inherited the mantle from the apologist mantle from Judge Walker.
Well, thank you very much for having me here. We've been very interested to hear what the federal government actually has to say about what their position is on this issue for years. So I'm glad we're getting some clarification on that. I guess since we're starting out by saying our political affiliations, this may surprise you. When I was your age, I was not a Democrat. But what may not surprise you so much, and I was registered Peace and Freedom. And still am. Which is why I think I have a slightly different interpretation, I guess, of the history of our marijuana laws than Mr. Rusinelli. Back in 1970, when the Controlled Substances Act was enacted, Congress didn't really know where to place marijuana. They didn't know enough about it. And so what they did was they formed a commission to study the issue. And they thought temporarily of placing marijuana in Schedule 1. They just kind of threw it there because they didn't know how harmful it was and whether it had any medical efficacy. So they formed what's known as the Schaefer Commission to study the issue. And the Schaefer Commission studied the issue and came back and said marijuana is pretty much, it has some harmful effects, but it's generally a benign substance and has been devilized